Hello, my dear students. Today, in this last lecture, we'll talk about the discipline. We'll continue with the discipline. As in our previous lecture, we have talked about the chart sheet. We have discussed the contents of the chart sheet. And today, we'll talk about the other things of discipline. We'll talk about the prerogative during the pendency of the proceedings and about the notice of change also. All these topics we are covering under Unit 4 and under the Industrial Disputes Act 1947. So, first of all, we'll talk about the chart sheet. As in the previous lecture, we have already discussed the content of the chart sheet. Now we talk about the service of chart sheet. As stated in the standing orders, accordingly, we should serve the charge sheet, and charge sheet should be served personally and against the signature on a duplicate copy. So while you are serving the charge sheet to a workman, you should take the signature of that workman that we have served the charge sheet on a duplicate copy of the charge sheet. And if the workman against whom you are just issuing this charge sheet is absent, or he is on leave or under suspension, so if the workman is on leave or he is absent or he is in suspension, then paste on wall of the residence of that delinquent worker discharge, and display on the notice board of the company also if the workman is just not receiving, and publish. The other option is you can go for the publication in the regional newspaper also, or you can send that by registered post as well. And notice, now we talk about the domestic inquiry. So in domestic inquiry, we should follow the rules laid down in the standing orders. So whenever there is a domestic inquiry against a workman, then we should follow the rules which are laid down in the standing orders. And we should try to understand the purpose of the domestic inquiry, that why we are conducting this domestic inquiry. And while we are conducting the domestic inquiry, we should provide an opportunity to defend to the workman. So, whenever someone is conducting a domestic inquiry, an opportunity should be provided to the workman to defend, and should also provide, employer should also provide an opportunity to evaluate the situation and decide the penalty to be imposed. So, employer should go to evaluate the situation and decide the penalty. What should be the penalty which should be imposed to the workman? And notice of inquiry should be sought. And in this notice of inquiry, notice to show date and time, which should be, specifically mentioned about the inquiry, when this inquiry will take place, on what date and what time, that should be specifically mentioned. And of course, about the venue of the inquiry also, that has to be mentioned in the notice of inquiry, which we are going to serve to the workman. And who will be the inquiry officer? The name of the inquiry officer has to be there in the notice of inquiry. And notice, for notice, or while you are serving the notice, the process, or this notice has to be served in the same manner as it is applicable to the charge sheet. And of course, here also the workman is having the right to defense. And For management, technical person should be there to defense or to represent the case. And for management, there has to be a technical person who understands well about the issues involved in the matter. And same right for the worker also. And in case worker is not able to handle the show alone, he can hire the lawyer to represent the cases. And as I told you, my dear students, that while you have served the notice of inquiry and now the inquiry is going on, then in this inquiry, when we talk about the evidences, then not mandatory to follow the procedure of CRPC 1973 or the Evidence Act 1872. And first statement of management to be taken. So whatever management wants to say, they can just share with the inquiry officer. And the cross examination would be by the workers representative here, and signatures of all concerned would be there on the records, or whatever you have recorded during the proceedings. On this, the signature of the concerned would be required, and examination and cross examination of the witnesses would be there, and object or disallow if the question raised is not pertinent or irrelevant, which is having no connection with the matter. Then these questions may be objected or disallowed, or may be treated as irrelevant questions for the purpose of the evidence process, means whatever is going on under the evidence. Now we talk about the show cause notice, my dear students. Show cause notice. See, before punishment, show cause notice highlighting the charges, finding of inquiry, possible penalty, and show cause should be given that why action should not be instituted against you. And serving of notice will not make the process invalid. As there is an important case also regarding this, Shane Bagra versus Additional Commissioner of Industries and Commerce, Jacob and others, advisable to give final opportunity before punishment inflicted. So whenever you are going to inflict the punishment, we should provide an opportunity to represent, and inquiry report should be given to the workmen also. Now we talk about the order. The principles of natural justice to be followed when we talk about the orders, and punishment should not be violated, or I beg your pardon, punishment should not violate section 73 of ESI Act. This 1948, this is regarding notice of dismissal, discharge during sickness, maternity or other benefit. So while the employee is in during the sickness period or the maternity benefit or I beg your pardon, maternity benefit she is availing, then notice of dismissal or discharge should not be served to the work in case of sickness and the maternity. And order without holding domestic inquiry or with the defective inquiry will not stand as labor court, or tribunal can interfere with such order under section 11A of Industrial Disputes Act 1947. So order without holding domestic inquiry or with defective inquiry, maybe the inquiry was conducted but it was a defective inquiry. So and it will not stand as labor court, of the tribunal can interfere with such order under section 11 of the Industrial Disputes Act 1947. Now, my dear students, I will show you certain formats which are related to the different charge sheets for different indiscipline. This is the format for charge sheet absenting without intimation. So here you will write down that who is issuing this charge sheet. Oh, I beg your pardon. Here you will mention to whom this charge sheet is being issued. You will mention the date as well, and the subject also. So as I have already told, the subject is absenting without intimation or anything related to this. So this is a kind of format you can follow, that you have been absent since you will mention the date, or overstaying leave granted since again you will mention the date, and absenting without leave, overstaying of leave is an offense as per rule. You will mention the rule number of our standing orders, and as such your act of absenting without intimation is a misconduct which attracts such punishment including termination of service. Accordingly, you are hereby called upon to explain in writing within 48 hours as to why appropriate action should not be taken against you. So in that way, you can just use this format for the purpose of issuing a charge sheet while a workman is absent without intimation. So you will mention the duration, for what duration the workman was absent, or if he was or she was overstaying leave granted, that then the date you will mention in the charge sheet, and then you will ask that because your act is without intimation is a misconduct, and which attracts such punishment including termination of service. So we are giving here the time 48 hours to explain in within 48 hours in writing, explain, and why appropriate action should not be taken against you. So in that way, we go for the issue the charge sheet. Then you can issue the charge sheet for misbehavior also. Again, you will mention that to whom you are addressing this charge sheet, the name of the workman, designation, maybe department, and and then you will just follow that it is reported that on such and such date, such and such time, you misbehaved. Then again, the name of the specific person with whom the workman has misbehaved, then the designation of the workman, and in the presence, then you mention the name of the witnesses in whose presence you have done this misbehavior, or disobeying orders and misbehaving are serious misconduct. As a rule, again you will mention the rule in the which rule of our standing orders and which attract the punishment including dismissal from services. And accordingly, you are hereby called upon to explain in writing within 48 hours as why appropriate action should not be taken against. So again, for misbehavior, you can just follow this format of charge sheet. Then charge sheet absenting without intimation. So again, you will mention that to whom you are just addressing this charge sheet, the name of the full name of the employee, the designation, department, everything you will mention, the date you will mention when you are issuing the charge sheet, and subject also. Subject also, you know, absenting without intimation, and you have been absent since such and such date or overstaying leave. So in that way, you would be just following this, as I have already told you, the format, and absenting without leave or overstaying of leave is an offense as per rule this under a standing order. So again, you would be following this format. Now, notice of inquiry, how you will issue the notice of inquiry, my dear students. I would just like to make you familiar with the notice of the inquiry. So you would be just issuing the notice, you will be addressing the workman to whom you would be issuing the notice of the inquiry, and date you will mention, on that, and then since the explanation given by you as cited above is found unsatisfactory, so you will mention the subject also, inquiry, your and regarding you mentioned the standing orders also, and charge sheet number also, date also, and your explanation date also. And since the explanation, then you will mention that since the explanation given by you or cited above is found unsatisfactory, you will give this all the details, whatever explanation you have given. And a domestic inquiry is being instituted of the, mention the standing orders number have been initiated beside the charge, and the inquiry will commence at 9:30 a.m. So mention the time also. Why we are mentioning it? At this time, employee would be just approaching the venue for the inquiry. So mention that under what rule of standing orders you are just issuing this. Mention at what time, what day, which date the workman has to be there for the inquiry purpose, and you are hereby required to present in person with or without a helper to give any clarification to defend the charges against you. And you are asking the workman that what do you want to say in your clarification to defend yourself. You come and just represent yourself. And Mr. and Mrs. would be, means whosoever is the inquiry officer, you will just mention the name of that inquiry officer also, and then it would be signed by the authorized person, and then you will issue this notice of inquiry. So this is again, format I have discussed with you for issuing the notice of inquiry. And now you can take this also show cause notice, the termination order. So you just you can easily find all those formats available on in different books and on different sites. You just have a look and try to write down certain, issue cause notices, certain charge sheets. You try to write down certain domestic inquiries details. So you would be just familiar with the process of the disciplinary action. Now we talk about the regulation of management prerogative during the pendency of proceedings under section 33, and conditions of services, etc., to remain unchanged during the pendency of proceedings. The main purpose of the industrial adjudication is to establish industrial peace. This purpose would be defeated unless the condition of the service of the workman and their right to continue in employment as far as possible remain unchanged during the pendency of proceedings before authorizes. Under the Industrial Dispute Act, Section 33 and 33A have been enacted for the purpose of achieving this object. And so, with the help of these sections, we are trying to achieve this regulation of management's prerogative during the pendency of proceedings under Section 33 and Section 33, which is incidentally the largest section. And so there are certain things which you can just go through with the help of Bear Act, also with the help of book also. Section 33 and 33A have been enacted for the purpose of achieving the object. Section 33, which is incidental, the largest section, and which provides that during the pendency of any conciliation proceeding before a conciliation officer or a board of any proceeding before arbitrator or labor court or tribunal or national tribunal in respect of an industrial dispute, no employer shall, clause A, in regard to any matter connected with the dispute alter to the prejudice of the workman concerned in such dispute the conditions of service applicable to them immediately before the commencement of such proceedings. So there is a restriction on this. And in clause B, for any misconduct connected with the dispute, discharge or punish, whether by dismissal or otherwise, any workman concerned in such dispute, save with the express permission in writing of the authority before which the proceedings is pending. So you have to obtain the permission in writing first. So otherwise you cannot make any changes. So there are certain restrictions imposed during the pendency of such proceedings of an industrial dispute, right, my dear students. So you can just have a look of all those clauses. And in every establishment, number of workmen to be recognized as protected workmen for the purpose of subsection 3 shall be 1% of the total number of workmen employed therein, subject to the minimum number of 5 protected workmen and a maximum number of 100 protected workmen. And for the aforesaid purpose, the appropriate government may make rules providing for the distribution of such protected workmen among various trade unions, if any, connected with the establishment, and the manner in which the workman may be chosen and recognized as protected workmen. So this is something, very important, which is given, that who would be treated as a protected workman. And where an employer makes an applicable to a conciliation officer or board or arbitrator or a tribunal or national tribunal labor code, uh, under the proviso to subsection 2 of for approval of the action taken by him, the authority concerned shall without delay hear such application and pass. So employer has to make an application and as expeditiously, I beg your pardon, expeditiously as possible such order in relation thereto as it deems fit. Now, my dear students, this is all about the proceedings and prerogative of the management. Now we talk about the notice of change and the section 9A. No employer who proposes to effect any change in the conditions of the service applicable to any workman in respect of any matter specified in the further schedule shall effect such change. Clause A says, without giving to the workman likely to be affected by such change a notice in the prescribed manner of the nature of the change proposed to be effected, or within 21 days of giving such notice, you can just bring that change in the service and service conditions, and provided that no notice shall be required for effecting any such change. Where the change is effected in concerns of any settlement of a work, then it will not be permitted. And where the workman likely to be affected by the change are persons to whom the fundamental and supplementary rules, civil services classification and control rules, civil services temporary rules, revised the rules, civil services regulations, civilians in defense services rules, or the Indian Railway Establishment Code, or any other rules or regulations that may be notified in this behalf by the appropriate government in the official gazette. So this is all about the notice of change, my dear students. While the employer is willing to make changes in the service of the conditions, we have to observe certain formalities what I have discussed with you. So thank you so much for today's lecture and patience listening. And I believe this lecture will give you an insight about the different aspects of charge sheet, that how we go for the show cause notice, how we go for the evidence is notice of inquiry, how do we serve domestic inquiry, how do we conduct. I believe, my dear students, this lecture will definitely help you. And this is all for today's lecture. Thank you so much. Have a nice time and have a good day. Thank you. Bye bye. Take care.